Hello friend, welcome to my YouTube channel. Today I am going to discuss a very interesting topic, and the topic is 14 opposition parties move Supreme Court against misuse of probe agencies. So what are the probe agencies? CBI and ED. These two are probe agencies. Okay, now CBI is controlled by Home Ministry and ED is controlled by Ministry of Finance. So what are the complaint of 14 opposition parties? Their complaint is central government is misusing CBI and ED against the political parties to silence their voice and to create an uneven playing ground in the field of politics. Okay. So their demand is to make a separate guideline for the political leader, in case they arrested by CBI and ED. And also another demand is they should not be arrested, and if arrested they will give immediate bail if they means the political leaders are not involved, in serious crimes or body harm crime. Body harm means to injure someone, to kill someone, to harm someone. Means if the political leaders are not involved in body harm crime, then they should be given bail or we should not be arrested. This is their demand. The Abhishek Manu Singhvi, a famous advocate, is representing the 14 opposition parties in the Supreme Court. This case was lodged in Supreme Court on 23rd March and 5th April 2023 was the date when the Supreme Court is hearing the case. Now after hearing the case, Supreme Court give their verdict. And what is the verdict? This is the verdict. Supreme Court rejects opposition plea, no exclusive rules for politician, same as rest. So the first demand of the 14 opposite political parties was to make a separate guideline for the political leader. Okay, so Supreme Court reject by telling them that political leaders are a citizen of our country. So the rule applicable for the normal citizen, the same rule will be applicable for the political leaders also. There should be no guideline, separate guideline for the political leaders. Now in the whole contest, whole page, there is a discuss between Abhishek Manu Singhvi and the Chief Justice of India, D.Y. Chandrachud. I will tell you each and every point. The first is, I am zooming it, refusing to entertain a plea by 14 political parties alleging selective and targeted use of central probe agencies such as the CBI and ED by the BJP-led central government against their leaders. The Supreme Court said Wednesday it can intervene in individual cases when the facts are before it, but cannot lay down separate general guideline only for politicians who stand absolutely on the same standing as the rest of the citizen of the country. This means that Supreme Court will not use any separate guideline for the political leaders because the political leaders stand absolutely on the same standing as the rest of the citizen of the country. Also Supreme Court said that, the Supreme Court said on Wednesday it can intervene in individual case. Means if any individual leader or group of leader is arrested by CBI ED, then they can appear before the Supreme Court. Okay. Individual case, not a general guideline. There should be no general guideline of all the political leaders. Okay. Next thing, the problem with this petition is that you are trying to extrapolate statistics into guidelines. The Chief Justice of India telling the opposition advocate, means Abhishek Manu Singhvi, that you are trying to extrapolate statistics into guidelines where the statistics only apply to politicians. Means statistic means like statistics only apply to politicians. Statistics means like policy making, decision making, what should be the decision, what should be the policy so that the state, the economy, the country will progress. That is called statistics. Statistics only apply to politicians, but Supreme Court guideline cannot be applied only to politicians or only to citizens. That is equal for everyone. Okay, but we cannot have guideline exclusively for politicians. Political leaders stand absolutely on the same standing as the citizen of the country. They do not claim a higher identity. How can there be a different set of procedure for them? Chief Justice of India D.Y. Chandrachud said when the plea came for hearing before him and Justice J.B. Pariwala. So, two Justice D.Y. Chandrachud is the Chief Justice along with Justice J.B. Pariwala also hearing the case. Both have the same opinion that we will listen only individual case. We will not have separate guideline for the politicians. Okay. Next is on the contention of the petitioners that skewed application of the law, that law had led to an uneven playing field and shrunk the space for dialogue. The CGI said when you say that space for opposition has shrunk, the remedy is in that space, the political space, not court. Means Abhishek Manu Singhvi, the opposition representation advocate, said that uneven playing field means central government want to create an uneven playing field in the field of politics by misusing CBI and ED. So politics is a playing field. Every politician has the right to play on the field, but misusing CBI and ED, central government want to create an uneven playing field. But what Chief Justice of India said, when you say that space for opposition has shrunk means squeezed, means Abhishek Manu Singhvi said that shrunk the space for dialogue, means want to silence the voice of opposition and want to create an uneven playing field. So CJI said that when you say that space for opposition has shrunk, the remedy is in that space, the political space, not court. Means you are saying, means Abhishek Manu Singhvi are saying that central government want to create an uneven playing field in the political field. So the answer lies in the political background, in the political ground, not in the court. If in your view that central government want to silence the politicians by using CBI and ED, then the answer lies in the politics, not in the court. Through politics you will raise your voice, not through court. Okay. Next is, now who are the 14 opposite parties? The petition had been moved by Congress, DMK, TMC, RJD, AAP, BRS, NCP, Shiv Sena, UBT, JMM, JDU, CPM, CPI, SP and NC. Almost all the opposition parties except I think BJD, Biju Janata Dala Odisha, except BJD, almost all the opposition political parties together moved to Supreme Court. Next is, the petitioner alleged selective and targeted use of central probe agencies against their leaders and sought laying down of guideline for arrest, remand and bail. I have already told you that they want to create a separate guideline for arrest, remand and bail. They sought certain prospectively applicable guidelines governing the arrest, remand and bail of person in offence that may or may not be punishable with imprisonment for above 7 years, not involving serious bodily harm. Okay, means if the political leader, if any political leader not involved in body harm, serious body harm case, body harm means killing someone, injured someone, hurting someone. if he not involved in body harm case, then if his offense, if the political leader's offense may or may not be punishable with imprisonment for above 7 years, then he should be granted bail or he should not arrest until he finally prove guilty by the court. Means if a political leader, suppose a political leader is involved in money laundering, so money laundering is not a body harm case, and in case of money laundering the punishment is less or more than 7 years, maybe less than 7 years or maybe more than 7 years. Okay, so if he is not involved in body harm case, then he should be given bail, he should not be arrested until he proved guilty, finally guilty by the court. Until he found guilty by the court, he should not be arrested, or if arrested, he should be given bail. Okay, that should be the guideline, new guideline set by Supreme Court. That is their demand. Appearing for the petitioner Wednesday, senior advocate Abhishek Manu Singhvi told the bench that statistics show a huge increase in CBI and ED cases between 2014 and 21, but there have been only 23 convictions. Okay, now, so he is telling about rate of conviction. So, rate of conviction is very low. As per Abhishek Manu Singhvi, CBI and ED rate of conviction is very low, means they are inefficient, and maximum cases is against the opposition leaders. Now, what CJI said against this? CJI pointed out that the conviction rate in the country was dismal even otherwise, means conviction rate of our country as a whole, not only case of CBI and ED, but as a whole the conviction rate is very dismal, means not satisfactory. For example, conviction rate of court is also very low. That doesn't mean that people will not move to court. Okay, so that should not be the argument. Next, Singhvi said he was not just on the rate of conviction of, means he is not only talking about conviction, but of the 121 political leaders probed by ED and 124 probed by CBI, he said 95% were from opposition. He said this has a chilling effect on the legitimacy of the political opposition. Now, what CJI told, the bench pointed out that it was not a plea by some aggrieved individual but 14 political parties. So, let's think that you are correct. Let's think you are correct that probe is against specially for the opposite leader. Then come individual to Supreme Court. Not a general guideline should be framed by the Supreme Court. CJ asked whether it can say no investigation or prosecution citing the statistics. He said that ultimately a politician too is basically a citizen, and that as a citizen all are amenable to the same law. Means just seeing the result, just seeing the conviction rate, we should not free a political leader. The conviction rate of ED is very less. That doesn't mean that we should free the opposite leader. Okay, all are citizen and law is applicable for all. Then Singhvi said he is not trying to interfere with any ongoing investigation. If the statistics show a skewed application of the law which has a chilling, harassing effect, he is seeking guideline against. He is not trying to interfere with any ongoing investigation. If the statistics show a skewed application of the law which has a chilling, harassing effect, he is seeking guideline against it. Again, he is talking about guidelines. He said 14 political parties represent 42% of the electorate across the spectrum, and that if they are affected, it means the people too are affected. Okay. Now, the bench referred to guidelines sought by the petitioner and said, you say for lesser offence punishable with less than 7 years jail term, there should be no arrest until the triple test is satisfied. Now, that is very important line. raised by Supreme Court. So Abhishek Manu Singhvi was saying that a political leader whose offence is punishable but less than 7 years there should be no arrest. As per demand by Abhishek Manu Singhvi, there should be no arrest for a political for jail term less than 7 years. There should be no arrest. Now, unless the triple test is satisfied. Now, what is triple test? Triple test is if a person is very dangerous, he can kill the witness, he can flee from the country, okay, or he can do anything to save himself, then that person is satisfied triple test. Satisfied triple test means the person is very dangerous, okay, and failing of triple test means the person is not dangerous, he will not flee from country, he will not kill the witness. And if a person triple test is satisfied, means Supreme Court is saying that unless the triple test is satisfied, means unless the person is very dangerous, he can kill the witness, unless triple test satisfied, there should not be no arrest. Is it your demand? Means we will wait to see that the person is flying out of the country, he is killing the witness, then we should arrest him. Is this your demand? But take cases which don't involve an attack on bodily integrity. Bodily integrity means body injury, bodily harm. Means this is another demand. Means if the leader is not involved in body harm, he should not be arrested. For example, there are financial scam of crores. Can we say don't arrest because it does not involve an attack on bodily integrity? Now, the triple test for arrest refers to flight risk. Flight risk means flee out of the country, reasonable apprehension of tampering evidence, influencing or intimidation of witnesses. Next, the CJI means Chief Justice of India pointed out that if the court grants the prayer, it will essentially be doing what the legislature is supposed to do. Now, that is very important. Means they are continuously saying about new guideline, new rule. If you want new rule, then move to legislature. That is the duty of legislature, means parliament, to make new rule, new law. What court will do with that? Go to parliament and make new rule, new guidelines to say that there should be no arrest in case not involving bodily harm or child sex abuse. That is for the legislature to do, he said. Means you want that a new rule should be framed that without bodily harm or with bodily harm or child sex, political leader should not be arrested. Then make rule in the legislature. Now finally they said, come back to us with even a single case or group of cases where you find that a political leader has been targeted to silence. Our problem as the Supreme Court is for us to start laying down guidelines in an abstract context without the facts of a particular case. The CJI said and referred to cases where the court had laid down guidelines regarding arrest and bail. He said all these are in the context of fact of situation, means come back to us. Now you can go back. Your case is dismissed. If you want to come back with us with single case or group case. Okay, then we will consider we should make a new guideline or not. Okay. Next is Singhvi, however, said whether the law is being weaponized for its slanted application, this will not be the answer. He said there is a deliberate and conscious weaponization of a particular branch of law, and that in a majority of the case arrest was on the ground of the gravity of the offence and the agencies were unable to show whether the triple test requirement had been met. Okay. The bench, however, said that if an individual comes to court, the law which it lays down as the highest court of the country may be regarding the facts of the case but not confined only to that case. On the basis of those facts, we can evolve a principle of general application based on the fact which come before us, but in the absence of specific fact for us to lay down general principle of law is again a dangerous proposition. Once we have facts in a case or group of case, then we can lay down law not just for that case the bench said. Means that the law means the agency's deliberate and conscious weaponization of a particular branch of law. Okay, so branch of law should be changed, new guidelines should be found, okay, to save the corrupt leaders from arrest by CBI and ED. That is their main funda. Okay, but the court continuously saying that come back with single case, come back to us with single case, we will consider whether the CBI or ED arrest is genuine or not. Then we will think whether should we make a new guideline or not. Finally, with the court reluctant to entertain the plea, Singhvi sought permission to withdraw it at this stage. The request was allowed by the court, which dismissed it as withdrawn. Means finally Abhishek Manu Singhvi withdrawn the case from the court allowed the withdrawn application. So means CBI and ED can freely go with that with their work. They can raid anywhere, they can investigate anyone, they can arrest anyone. Okay, they are free to do that. That is the observation of Supreme Court against the petition. So that is the discussion. If you like the discussion, please like the video, subscribe my channel. We will meet with new topic. Thank you.